fun, man. Keep your sweater closed.
Hey, I could get in trouble.
That's right. So, be cool.
Boom.
Nothing for me today, thanks.
It looks like you gained some weight since you came in.
It's just a prank. I'm pledging a fraternity.
Don't sweat it, sweetie. I won't tell.
Hey everybody, welcome back to Garden State CLE, and this is going to be our judicial introduction to shoplifting for you judges who are out there. Pay particular attention, because I've got one of the preeminent shoplifting judicial experts in the state of New Jersey with me today. Please say hello everybody to the Honorable, and I do mean Honorable, H. Robert Switzer, who has just recently retired after 37 and a half years from the bench.
Where I came from, Atlantic County, I know several stores that went out of business because they couldn't afford to be in business because of the shrinkage factor coming out of the store.
Okay.
So I knew what the impact of a great amount of shoplifting would do to a store, so I took a serious stance about shoplifting, but that doesn't mean I took an unfair stance.
Well, I guess my question is there anything wrong from an ethical standpoint for a judge to be sensitive to local law enforcement problems? It could be truancy, it could be vagrancy, it could be some kind of pornography going on, or some localized drug or opiate problem. In other words, certain municipalities have certain unique criminal justice problems. Is there anything wrong with a judge giving extra attention to those things?
In a general sense, no. If you want to talk general philosophy of the court, I don't think there's any problem with that. But even on those grounds, I never talked to one elected official who was attempting to sway me one way or another over 38 years. I was very lucky in that regard.
I mean, let's say you have offense X. Would you treat offense X differently in one town than you treat it in a different town? Because it's in the first town, it's a much more important issue, not so important in the other town.
I try not to do that.
Okay. So everybody gets treated the same?
Equally across the board, that's correct.
All people are equally worthless in your eyes.
Equal justice under the law, I'd like to think.
All right.
Not equally worthless.
One additional thing I want to get into before we get into the actual statute, because these collateral matters are actually sometimes much more important than the actual mechanics of the statute. You get all kinds of defendants coming in front of you. You have ones that are going to have to go to jail. Okay. Under what circumstances would you allow them for a third offender to not get a jail term? Would it have to be something in terms of age or health or something very sympathetic about the defendant?
Well, if it's a third offense in New Jersey, there's a mandatory jail sentence of 90 days, so they had to receive a jail sentence.
No, I'm talking about that you would allow a plea agreement to go forward, charging them with theft or improper behavior or something else, something for which there was a factual basis, which would, in essence, take away the mandatory nature of the jail term.
I would never do that.
You wouldn't do that?
No.
Wouldn't there ever be any circumstance where you would consider having the person not do it because of, let's say, health issues or something?
Well, if there's health issues, there's other ways you can do the incarceration, such as on a bracelet,
right,
or they call it a SLAP program down in Atlantic County. It was called work release. But, other ways you can skin the cat in that regard.
So a prosecutor who would come to you with that, basically you'd say that's not in the interest of justice?
Yes.
Okay. Let's change it. Supposing that you have someone who is a public official. By that I mean this is an individual who has employment with some political subdivision of the state of New Jersey. No one is going to argue seriously that shoplifting is not an offense involving dishonesty. All right? So we're dealing with a mandatory forfeiture of public office. Right?
If the prosecutor requests it, yes.
Okay. Well, let me ask you this then. I mean, suppose the prosecutor didn't ask it, but you knew this was a public official. You'd forfeit his office anyway, right?
Only if the prosecutor requested it, because it can be waived.
But it can't be waived by the municipal prosecutor. It can only be waived by the county prosecutor or by the attorney general.
That's correct.
So my question to you is, irrespective of whether there's a request from the municipal prosecutor, in the absence of an application from the state or from the county, you're going to forfeit this guy's public office, would you not?
I would ask the question if they're requesting it to be taken.
Okay.
And if they did request to be taken, yes, I think in that situation I have no choice, because under the statute, shoplifting is a crime of, or an offense of moral turpitude, which means an offense of dishonesty. Under the statute, 2C, if a person commits an offense or a crime of dishonesty, then the forfeiture is mandatory.
Correct. So the starting point for you doing this is if you are an employee of a political subdivision of the state of New Jersey and you're convicted of an offense involving dishonesty, there's a mandatory forfeiture of public office, which is going to include shoplifting or any other title, a Chapter 20 offense. Okay? You agree with that?
Yes.
Okay. And in the absence of a waiver application from the Attorney General or from the county prosecutor,
Yes.
this is just the way it's going to be.
Yes. The
problem that you run into is that neither the prosecutor nor you may realize that the person has public employment. And it may be the guy only has a part-time job. Maybe he works as a greenskeeper over at the county golf course or something like that. It's not like those cases where the offense touches on the individual's office, because those are self-evident. You read that from the complaint. But you're not having any pre-sentence investigation done on shoplifting.
No.
So it may be that you're going to sentence someone without knowing that he has public employment. And under those circumstances, you'd have no way of implementing the forfeiture of public office.
Unless it was brought to my attention.
Correct. Do you think it's a good idea for judges who are confronted with people who are pleading guilty or getting found guilty of violations of the law that constitute an offense involving dishonesty to inquire of the defendant as part of the sentencing process as to whether or not they have public employment? So that would be every offense under Chapter 20, every offense under Chapter 21, any offense involving some type of disorderly persons level perjury or giving a false name to the police or signing a false name on a public document. I
really don't think so. I think that in those cases, the fact that someone's a public employee after a time becomes self-evident to the court.
Okay.
I just recently, before I left the bench, tried a conflict case out of Margate, where a Margate firefighter was charged with shoplifting $6.54 from a Wawa.
Right.
And it was tried by a county prosecutor, and I'm thinking to myself, why is a county prosecutor getting involved with $6.54 shoplifting charge? What it was is that this guy apparently had been doing it over and over and over again in Margate, and they wanted to put an end to it because he thought he was special.
He was, till he got caught.
Right. And so they came in and prosecuted. It wasn't usual running into a shoplifting charge because many of the store employees didn't know what was going on. It was brought by another police officer who at the time from another municipality in Atlantic County observed the shoplifting occur in the store and testified in court against this firefighter. I convicted him. It was brought by a county prosecutor. Then we went to the sentencing phase of the trial, and I asked on the record, are you willing to waive this? Are you asking the court to take his job and terminate his employment? And they said we want his employment terminated. So I had no choice in the matter at that point.
Correct.
So I entered the order, went up on appeal, was affirmed on appeal.
Yeah, in fact, even in those, my understanding of the case law is that even in those situations where there's been a waiver request from the AG or from the county prosecutor, the trial judge still gets to make the final call.
That's right.
Ultimately, whether it's going to be a forfeiture is up to you. But in the absence of a request, my sense is it's mandatory. There's something else I want to mention to you. This is more judicial than legislative in terms of its view of the importance of shoplifting. But there's a case out there, and I think it was written by Judge Karchman when he was on the appellate division, about de minimis applications while shoplifting cases. And basically this stands for the proposition that there's no such thing as a de minimis application on a shoplifting case. I mean, although theoretically make the application, that law division or the assignment judges should not be granting de minimis applications on shoplifting because it defeats the whole purpose of the shoplifting statute. Are you familiar with that at all, Judge?
Yes, I am.
Okay. And do you have any thoughts on that?
I think Judge Carson was right, because shoplifting can be for as little as 50 cents. I once had a person who was charged with stealing a candy bar, 50 cents, and I put him in jail for 6 months.
Right.
Well, they called me from the county jail and they said, did you actually put this person in jail for 6 months because he stole a candy bar, 50 cents? I said, yes, I did. And I said, do you want to know why? I said, yes, we'd like to know why. I said, his 21st conviction. So, I mean, you know, he already hit that level where any offense before me, he would get 6 months.
Or anybody else in the state, you would hope.
Well, you would hope, but, you know, because I had many run-ins with this guy in the past. He knew my position. He pled guilty without a trial.
Right.
And so it's a very serious offense because shoplifting affects everyone. It affects the profit margin of stores, so it affects the prices which stores charge, and therefore it affects everyone. Stores can be competitive up to a point, but if they have a large shrinkage factor coming out of the store, it affects everyone shopping in that store.
Well, there's also another cost too, which is the amount of money that the stores have to pay to combat shoplifting in terms of personnel, security footage, and the time that's taken away that these people have to come to court and deal with these things.
But the law deals with that.
Yeah, and also sometimes they wind up getting hurt too, and they have to deal with resisting individuals.
Or they're charged with robbery at that point in time. They
should be. Let's talk about the ways you commit shoplifting in New Jersey. My recollection is there's 6 different ways you can do it. The first is the easiest. It's just the general asportation aspect of it. And the asportation differs from the normal theft of movable property because it has to be merchandised. Let me just look at the elements here for a second. So we're talking about you have to require purposeful conduct. This is going to be under 2C20-11B1. So to purposely take possession of, carry away, transfer, or cause to be carried away. And it says here, merchandise. Okay? Now here's the definition of merchandise. Merchandise is in 2C2011A3. Goods, chattel, foodstuffs, or wares of any type of description, regardless of the value thereof. Okay? So your 50-cent candy bar, which, by the way, is pretty expensive for a candy bar.
This was back in the 80s.
Oh, okay. Oh, I wasn't born then, so I'm just going to rely on your word. So the only difference that I see between just a normal theft of movable property and a shoplifting under B1 is the fact that you're dealing with merchandise. Would you agree?
Yes, but that merchandise can include, for example, perfume testers on the counter in a store,
right? Like
a Bosco's.
Sure.
It can include other stuff in the store which is not typically for sale, such as things off a mannequin. It has a pretty broad definition.
You talking about the mannequin itself, or are you talking about things that the mannequin is wearing?
The mannequin itself, things the mannequin is wearing.
Well, see, I think you'd have a good defense there in the sense that this is where people it may be good, it may not be good. If I had a case like that, I would argue that it's not merchandise. The guy's guilty of theft, and you can amend, from one theft to another based on the proofs. So I would be arguing to the court, if that was what the guy stole, they can prove it, that it wasn't a shoplifting case, it's just a straight theft of property case because the mannequin doesn't meet the definition. That's good because it may help your guy avoid a mandatory jail sentence.
But how about a tester?
I guess you can make the same argument. They're not selling testers, are they?
Well, no, but I think it's still is considered to be merchandise under the definition of the statute.
All right, well, let's go back and look at it again. Just to make sure we know we're both reading from the same script here. Here's the definition of merchandise. Any goods, chattels, foodstuffs, or wares of any type of description, regardless of the value thereof. So
it's pretty broad.
It is pretty broad. I don't think mannequins constitutes goods, though, unless it's a mannequin store.
Yeah.
So that's the distinction between the asportation in 2C2011B1 and the normal theft of movable property under 2C20-3A. The next one is the main one that we have to deal with. This is the big problem child. This is the one that's charged more than any other one.
Concealment.
That's concealment, okay. This is 2C2011B2. Let me read the statute. It's against the law in New Jersey. Who knew? For any person to purposely conceal upon this person or otherwise any merchandise for sale by the store or the retail mercantile establishment with the intention of depriving the merchant of the possession, use, or benefit of such merchandise, or converting the same to the use of such person without paying for the merchandise, the value thereof. Okay? What's all that mean? Sounds pretty complicated.
That means if you put something in your pocket or something in your purse, or you hide something under your baby's stroller in the store, that you can be found guilty of shoplifting, doing that in and of itself. And I disagree with that.
If you hide something on the baby, does the baby go to family court once you get caught?
No.
I've had a million baby cases.
I had a million baby cases too.
Okay. When I used to tell my clients this is what the statute means. If you conceal, you steal. And really, when we get into the presumption that they have, you'll see where I'm coming from here. But it sounds to me like you have kind of a fundamental disagreement with the statute.
Yes, I do. Because the statute itself has a contradiction. Because the statute says that if you conceal items, it creates, and these are statutory language now, it creates a presumption of intent to deprive.
Right.
The case law says that's not a presumption to permissive inference.
Correct.
But it's a big feather in the state's cap if they can show concealment. But the thing is, with shoplifting in New Jersey, shoplifting has to be a completed crime. It's still a crime of theft. And there are no attempts to shoplift or no attempts to do any disorderly person's offense in the state of New Jersey under the statutory definition of 2C.
Two exceptions to it, believe it or not. One is simple assault, and the other one is hindering the administration of law. But both those have the word attempt right in the definition.
But under 2C20, there are no attempts.
You can't attempt a theft.
Can't attempt a theft.
DP level theft.
Yes, DP level theft. So, in my mind, since it's a theft offense, there has to be an opportunity to pay for the item before you can be charged with or found guilty of the charge of shoplifting.
All right, so if you were watching a videotape and you saw concealment, okay, and then the store security came and arrested him immediately based upon the concealment.
Yes.
Okay. It sounds to me from what you're saying that would not be enough for you to find the person guilty. You want to see him go up to the cash register or try to leave the store or something of that nature.
I would go even further than that. I wouldn't find probable cause to issue a summons.
Wow. Really?
Yes.
Okay.
And I had discussions with my court administrators as to that. This is my feeling. It's the law. They agree with me. There has to be passage beyond the last point of sale, I think, before a person can be charged.
But that's not in the statute. This is just your personal
This is my interpretation of the statute.
Okay, but this is personal to you.
I'm dealing with the conflict between the creation of the presumption of permissive inference and the statutory language of concealment.
All right.
And I'm going in favor of the defendant there because I have seen cases where a person leaving the store knows that they're being followed by security in the store. And before they leave the store, they discharge all their items and throw them away before they leave the door.
Right.
And I find that to be a renunciation of the intent to deprive.
Okay. Let me kind of support your argument here, Judge. Because my reading of 2C 2011b2 requires two types of purposeful conduct. Okay? By purposeful, I'm using the normal Title 2C definition, and that it's your conscious object to bring about a particular result. All right? So the first thing is that the concealment itself has to be purposeful. Okay? It can't be negligent, can't be reckless. You just put something in your pocket per se while you're tending to a child and forget about it. It has to be your purpose, your conscious object, to conceal whatever the item is, okay? Item of merchandise. Then it says, and this is the part that really kind of supports your position, that you have to do it with the intention of depriving the merchant of the possession, use, or benefit of the merchandise, okay? So it has to be your conscious object to basically deprive the merchant of that merchandise. And the best evidence of that is when you see them walk past every cash register in the store and out the door with merchandise that they had purposefully concealed.
Well, we had a case once where, and there have been other cases also, because some people can conceal and it can be a mistake,
right,
rather than the intent to deprive. Such as a woman went to a store with a baby and 3 other children who were small, and you could see on the tape that the children were really giving her a hard time. She had put something on the top of the baby stroller under a blanket, and her testimony was that she forgot it was there because she was trying to deal with the children rather than pay for the item. Then she just forgot about it and left with Sears, on the major part of the mall at the Hamilton Mall. And this was a woman who was an accountant. I mean, she had no prior record. And I found her not guilty because I didn't believe that she had the intent to defraud.
Was there,
Although under the statute of concealment, I could have found her guilty.
Oh, I agree with it if you thought that was her purpose.
Right.
But you didn't believe that was her purpose.
No, I did not.
So she's not guilty.
Yes.
There's a case, is it the Henry versus Shoppers World, or do you remember the case I'm talking about?
Yes.
I think it involved somebody who put a hat on his head.
Yes. It's a coat.
Was it a coat?
Yes.
Do you remember the case, Judge?
Yes.
What's the case about?
It's a person who went to a store, put a coat on their person, and that coat had a tag on it.
Right.
And so the store had a probable cause to believe that they were shoplifting the item from the store.
Right.
And they were stopped. And it was an issue about detainment, about how long can detainment be. Because under the statute, you can reasonably detain people if you have probable cause to believe that they're guilty of or involved in the act of shoplifting.
The key is, though, that for judges who are hearing these cases and having to make factual determinations, they're going to have to make a determination that the evidence shows that the concealment was purposeful and not something collateral or incidental or negligently done. The person forgot or was distracted because of children. I had many of those cases. And number 2, that the concealment was done with the purpose of permanently depriving the merchant of the value of the merchandise.
And for me, sealing the deal is walking past the point of last seal.
Right. Because it's look, you can't look inside the person's mind.
You can't.
So you got to judge this through circumstantial evidence, and the fact the person purposely concealed and now is walking out past the last opportunity to pay, it's highly probative circumstantial evidence that's the purpose of the defendant.
And also you have the permissive inference created by the statute.
Yeah, and let's talk about that for a couple seconds, okay? I don't want to use. Actually refuse the word presumption. Probably not professional because it's right in the statute. But I'm going to follow State v. Humphreys and say that you can't have a presumption in a criminal or quasi-criminal case that is unconstitutional. That these elements of the so-called presumption are nothing more than indicia or what would you call them, Judge? What's a good word?
A factor.
They're factors that you can consider, but they're not conclusive. You can have a conclusive presumption all day long in civil cases, but not in this.
But I would say that even if you use the word presumption, there's always a rebuttable presumption.
Well, I agree, but would you agree with me, though, that the law is basically that it's unconstitutional to have a conclusive presumption in a criminal case?
Absolutely.
Okay.
Absolutely.
So we're going to talk about these as permissive inferences. These are inferences that the court can either draw or not draw. It's not mandatory like it would be in a civil case. We're talking about a presumption in a civil case.
When I was hearing cases, shoplifting cases, if the state did not have the benefit of the permissive inference, in other words, the item was not concealed,
right,
the state had a very difficult time proving intent to defraud.
Right. Much easier when you have concealment.
Oh, absolutely.
So let's look at the so-called presumption. I hate saying that. I wish the legislature would just change it to say permissive inference. It's under 2C2011D. Here we go. Any person who purposely concealing unpurchased merchandise, which is what we're talking about here, of their store or other retail mercantile establishment, either on the premises or outside of the premises. Oh, I got to be careful when I buy Christmas trees from now on. Of such store or other retail mercantile shall be prima facie presumed to have concealed such merchandise with the intention of depriving the merchant of the possession or use of the value of the merchandise without paying the full retail value thereof, and the finding of such merchandise concealed upon the person or on the belongings of such person shall be prima facie evidence of purposeful concealment. And if such person conceals or causes to be concealed such merchandise upon the person or among the belongings of another, like a baby, the finding of same shall also be prima facie evidence of willful concealment on the part of the person so concealing such merchandise. So, again, it would seem to me that the permissive inference in this section of it really makes it easy to convict somebody who's concealed something.
Absolutely. Much easier than if the item is not concealed.
Okay. But if it is, let's assume that there is concealment, okay? You just had an extraordinarily high bar for the state in order to convict these individuals. You really demand a lot of evidence.
Yes.
But would you agree with me that the amount that you demanded personally and the amount that's probably okay, given this permissive inference, that there's a big difference here? You don't need all that evidence to convict somebody.
Well, once the state has shown concealment through the facts of the case,
right, and
once the defendant has passed the point of last sale, then you have a completed crime, in my estimation.
I agree.
Absent mistake.
I agree.
It's
a permissive inference. It can be rebutted.
Always
or
has
rejected.
the option of testifying or getting others testify on their behalf that it was a mistake and why it was a mistake.
And there can be many reasons for that.
Absolutely.
But what I'm trying to get back at is a statement you made before, which is a little surprising to me, that if the videotape that you had, assuming you had a videotape, showed purposeful concealment, and then immediately the store security people rush in and grab the people, that you wouldn't issue probable cause on that.
No.
Not even though there's a permissive inference that the concealment was done for that purpose.
Because it's not a completed crime. That's why I wouldn't issue probable cause.
Okay. All right.
Because they were caught inside the store before the opportunity to go up to the register and pay for the items that they had in their possession.
Got it. Okay. I'm not suggesting that your position is unreasonable at all. I'm just wondering whether or not it's legally required.
If there was an attempt to shoplift the state of New Jersey, then yes, there would be probable cause for that. But under the state statute, there is no attempts.
Okay. So what we're left with here on these probable cause determinations, and I think mostly store personnel are trained to let these people, once they have them in their sights and they see them, just monitor them, watch them, and wait for the opportune moment.
Not all. It's most, yes, I would agree.
And I think sometimes, too, you see them getting, detained outside the store so as to not disturb the other customers during their experience. These are training issues, though, for the store security personnel.
Say in a situation where you have a supermarket and you get them past the point of the register, but they still haven't left the store.
Right.
Well, that's past the point of last sale.
Right.
So I would say at that point in time, it would be appropriate to apprehend the person at that point in time.
Gotcha. All right. For the judges who are watching us out there, they should realize, though, that they're going to be dealing with 2C2011B2 more than any other type of shoplifting. Would you agree?
Yes, but I'd still think that it goes back to asportation rather than concealment.
Okay. But they should be familiar with what concealment is, that it requires purposeful conduct.
Yes.
That they have to demonstrate an intention to permanently deprive, and that understand the inner workings between this permissive inference in subsection D and the concealment, because they really kind of go hand in hand, okay? And then, call the case, see whether or not you're persuaded beyond a reasonable doubt.
Yes.
The next way is underringing, and we used to get a lot of these cases.
So do we.
Typically, you'd have two defendants in the underringing case. You'd have the person who's doing the shoplifting, and then you'll have a store employee.
The cashier.
Or whoever it may be. And these were difficult cases, because it's hard for these individuals to get a job again after they've been fired for engaging in some type of theft.
And I wouldn't take that as a typical case of shoplifting involving the store employee, because not only were they committing a criminal offense, but they were violating their implicit agreement of trust they had with their employer not to rip off their employer,
right?
Which they were doing.
Yeah, and we used to have that. It was a significant aggravating factor when it came to sentencing because of the trust that had been reposed in this individual, which had been violated.
Right.
And by the way, you're doing it for your cousin, that's one thing. Sometimes you'd be doing it for a whole bunch of people and getting all kinds of kickbacks.
Oh, absolutely.
So we saw it in different ways, but it becomes a much more serious case, as you and I are both indicating, because of the violation of trust. So an enhanced sentence, you're weighing the aggravating and mitigating factors.
And I would put that on the record.
Yeah,
yes.
It's not unreasonable under those circumstances.
Yes, as an aggravating factor of sentencing.
Correct. Now, you do have cases, though, where there is just sloppy bookkeeping, you know, and people make mistakes. So you've had those, right?
Yes.
You've had situations, I guess, where you've had to acquit people because you weren't satisfied this was purposeful misconduct.
Oh, absolutely.
Do you remember any off the top of your head?
Yes, there are cases involving making your mistakes at the register, putting the wrong item in. Now it's much harder to do now. Now it's everything is swiped, scanned. But before, they had to put the actual price of it in. Sometimes things were discounted, and sometimes things were not.
Right.
So you'd have mistakes made by the cashier at the time, and in that estimation, I think that creates reasonable doubt.
Here's the definition of an underring, and it says it's under subsection A9. Underring means to cause the cash register or other sale recording device to reflect less than the full retail value of the merchandise. And the actual offense for underring is it's a shoplifting offense for any person to purposely to underring with the intention of depriving the merchant the full retail value thereof. Okay, so I know that we had a whole bunch of different scams involved in underrings. I mean, I was there when they did have cash registers, and then toward the end, they were scanning everything. But they weren't scanning everything. They were scanning, everything except one item or two items.
That was the scam at the end. They would not scan everything. They would scan literally like 20 items. They'd scan 2.
Or they'd scan 18 and let 2 go.
Yeah.
Of course, that'd be the 2 most expensive.
Right.
Then we also used to get, and I forget how this particular scam worked, but it had to do with some type of card they would get, like a discount card or something of that nature. And there were sometimes that people would come in with phony discount cards to get money back. I forget how they did it. Human beings have tremendous ingenuity when it comes to stealing.
Absolutely.
How frequently did you get these underring type cases?
I would say that'd be 20% of our cases.
All right. Tell me about switching the tag. What is tag switching all
Well,
about?
you would take a less expensive price tag and put it on the item you're attempting to purchase.
Right.
And say take a $30 item down to $3.99 and present it for sale, and that would be scanned and they would be put through as a $3.99 sale rather than a $30 sale.
And how often did you get those types of cases?
I'd say that another 10 to 15% of my caseload.
Wow. This is under B3 for any person to purposely alter, transfer, or remove any label, price tag, or other marking, indicia of value, or any other markings, which aid in determining the value affixed to the merchandise displayed, held, or stored, or offered for sale by any store or other retail mercantile establishment, and to attempt to purchase such merchandise personally or in concert with another at less than the full retail value with the intention of depriving the merchandise of all or so on the part of the value thereof.
If the merchant made a mistake
Right.
and had the wrong price tag on the item, then the merchant has to eat that.
Sure.
Okay, but if the state can prove beyond a reasonable doubt that the person charged with shoplifting actually transferred the tag to that item,
Or altered it or removed it or whatever.
altered it, removed it, whatever, then that's shoplifting.
Got it. Okay. Now, the first cousin of the tag switching is container switching. Let me just read the... I don't remember ever getting container switching.
I don't remember either.
But it's a shoplifting to purposely transfer any merchandise displayed, held, or stored, or offered for sale by any store or other retail merchandise establishment from the container in which shall be displayed to any other container with the intention of depriving the merchant of all or some of the retail value thereof. Now you're getting me to start to think about these mannequins again. Maybe the mannequin has on some blouse or something, and the person takes off the mannequin and throws it into a bag. What do you think?
Well, we've had cases where people come into stores and they start just grabbing stuff and putting it in duffel bags.
Right.
And just walking off with a duffel bag off the rack, you know.
Did they steal the duffel bag and the merchandise?
Well, in some cases they have.
By the way, did you ever have those cases where you had like just an invasion of like 20 shoplifters at once, where we go through and in a 5-minute period just kind of wreck the store and then take off?
Yeah, absolutely. We had one case where this person, this is the truth, this is before flat screen TVs, came off a bus, walked into Bradley's, stole one of those big TVs, not flat screens, the big TVs, walked out of the store without paying for the item. I was waiting for a bus.
Well, how's that happen?
I don't know. And I mean, I'm just thinking to myself, what is this person doing? I mean, obviously it's no charge of concealment there, but he never presented the item for sale.
Last one I want to talk about, by the way, is shopping carts. Ever have any shopping cart cases?
No, I know it's in the statute. We never had a shopping cart case. No.
But I want the judge out there to realize that by walking up with a shopping cart that belongs to the establishment, that's constitutes shoplifting also.
Under the statute it does, yes.
There's one other offense that's here. It's not shoplifting. It's its own sort of first offense. And that deals with these so-called anti-shoplifting devices. And you'd see them talk about these duffel bags. I used to see duffel bags that inside they would have all kinds of aluminum that would be lining the inside. So presumably they could pass through the store detectors. And they had like a thing that would remove the whatever those things they put on merch on, like clothing, for example. Tags. Take that off the anti-shoplifting tag. It could actually remove it just like that, and out the door they would go. Do you remember any cases like that?
Yes, and we've had cases where items have been damaged by reason that they didn't have the proper machine to take those tags off. And so the merchant would be looking for restitution on the value of the merchandise because the fact that not only was there a criminal offense occurring there, but the merchandise was damaged such that that merchandise could not be resold, even when it was recovered.
All right. Now, we're going to do a lightning round now, and I'm going to throw a whole bunch of legal issues at you because you've confronted all these 1,000 times. The judges who are watching us may not have had this yet, so let's take it from the top. Okay. All right? Sure. Do you or did you demand that the actual merchandise that had been the subject of the shoplifting, if it's recovered, be produced at trial, or were you happy with facsimiles, photographs, and things like that?
I did not demand that the actual item be brought into the courtroom. There's a number of reasons for that. The merchant wants to put it back on the shelves for resale. I was not going to get involved in that. They had a picture or a description of the item that was good enough for me. That's a matter of the state's proofs, and I wasn't going to get involved in that.
All right. And the other aspect of it, again, which you should not be involved in, is dealing with storage and availability. Okay. Who's going to store these physical items, all 50,000 of them, while you're waiting to go to trial and find them?
Believe it or not, the court does.
Well, that's ridiculous.
I mean, but
if it's not, assuming it's before it's in evidence.
No, not before it's in evidence. Once in evidence.
All right. That's a different situation. I'm talking about pre-trial.
Pre-trial, that's the store's responsibility, the state's responsibility.
Okay. That. But you would be satisfied with facsimile evidence in terms of a photograph and things like that?
Yes.
All right.
Yes.
And I guess it would be easier to provide that to the defense, too, if they want some discovery.
Yes.
This is what it is.
Yes.
Okay. So it's not a problem for you?
No.
All right. Next, video evidence, okay? It's not required under the statute. It can be extremely probative either way. We know from the recent Supreme Court case of State v. Stein that it's normally going to be highly relevant to one side or the other. How did you have any problems in terms of just the normal evidentiary procedures about having the tapes authenticated and then having moved in evidence and then utilizing them to make your determinations?
No, as a matter of fact, most of our trials involve videotapes.
Okay.
I would say 95% of our trials involve videotapes.
And what's your sense in terms of their utility as a judge?
Oh, that would be very helpful. Very helpful because, you had the store's detective saying one thing, the defendant saying something else, but the videotape doesn't lie. And the videotape doesn't lie. It shows what's going on in the store. And it's very clear in certain cases because you're looking down on the floor from cameras above, and it's very clear as to what's happening.
Did you find that you were much more likely to acquit somebody with a tape than without a tape?
No, not really. I found I was much more likely to convict someone with a tape because it would show what was actually going on in the store. And their denial that they took the item out of the store laid flat on its face if you saw them taking the item out of the store on the tape.
I can't imagine why these cases would go to trial in the first place.
Well, I can't imagine either. But, we had with tapes, we had very few trials.
All right, but the tape is being rendered, so to speak, by a private entity. Okay, it's not being done by a political subdivision of the state of New Jersey.
No.
So if the store decides they want to destroy the tape, or it's not safe for whatever reason, and that's going to work a detriment to the defendant, is this something that's subject to a halt motion or anything like that?
Well, I really never had to encounter that issue.
Okay.
So I really don't know. It may be a Brady violation. I don't know.
I don't think it's going to be a Brady violation because we're not talking about government action here. We're talking about a private enterprise.
Yes.
For the defense bar out there, the way I used to handle it is I would serve a subpoena ducus tecum on the store and have them produce it on the day of trial or whatever day I wanted it there. At least that would preserve it, and if they didn't do it after they'd been served with a subpoena,
most certainly would be discoverable, and if it was not produced in discovery, then I would be signing off with it.
Yeah, I wouldn't want to rely upon the municipal prosecutor to track that stuff down.
Well, I mean, under the rules, that's municipal prosecutor's responsibility, either in cases involving private entities as opposed to state employees.
All right. Now, we are dealing many times with non-government action. These are private store security personnel. To the extent they're detaining individuals, it's under the common law of arrest, and it's also extended by statute.
Yes.
Many times in my experience, they would extract confessions out of individuals, especially employees who are engaged in underringing and things of that nature, and really put the squeeze on them to get them to write out some goofy confession in longhand and sign it. Many times they would get confessions out of individuals who would be detained for shoplifting purposes. And there's no obligation of these individuals to Mirandize them or anything else.
No, there isn't.
The only thing that would be required legally for the court to hear it is whether or not it was voluntary. If it's voluntary, the court can consider it. The only downside is that the court determined it would be involuntary.
Yes.
Do you agree with that?
Absolutely.
Okay. So
and that would apply for the Fourth Amendment also, as the
that's what I'm trying to make. They don't have any obligation to be reasonable because they're not law enforcement.
Yes.
So they can search people down, pat them down, conduct all kinds of crazy searches because the Fourth Amendment doesn't apply to them. You know? To the extent that they're detaining people, as I said a moment ago, they're just doing it under the New Jersey common law of arrest.
Right.
Now, so I guess what I'm trying to suggest is this. If there's a motion filed to suppress some type of admission or confession, I don't know that the defense has any standing to challenge that if it was taken by store personnel or merchants who are not acting as agents of the government.
It would only be a very narrow exception as to whether or not that the confession was taken voluntarily.
Correct. That would be the only issue that would be relevant to the court.
Yes.
And in terms of, they patted me down, they searched this, they searched my bag, whatever, there's no Fourth Amendment issue either, right?
Unless the store person was acting as an agent for the state.
Right.
And so I've had cases like that.
Okay. What would you do in a situation where, and I've had this happen too, where the person who's the part-time person working for the store is also a law enforcement officer, police officer, full-time police officer, off-duty, working for the store. What do you have under those circumstances? I told you I was going to get these crazy questions.
Okay. I would say you'd have to look at the nature of the employment at that point in time and determine whether or not he was acting in his official duties as a police officer, or whether he was acting as moonlighting in another job.
Right. It gets very confusing. Because I'll just extend this one more. I don't know if you've ever confronted this issue, but you have police officers off duty, minding their own business, not even in uniform, and they decide they see some violation in their neighborhood, and they decide that they're going to write a ticket, and they serve a summons complaint for a traffic ticket on a neighbor or something like that. And the question always becomes, can a police officer who's off duty do a summons complaint without judicial intervention, without a court making a probable cause determination? See what I'm saying?
Yes.
What do you think about that?
I'd say no. I'd say that in that situation, they would have that probable cause determination made by the court.
All right. Well, if you say so, that's the law. That's not relevant to what we're talking about here. So since we're on those lines, I want to talk about the immunity, because there's a couple of statutory immunities in here which kind of go hand in hand with these merchants.
Yes.
Again, these immunities are pretty much universal throughout the United States, so what I'm going to be giving you really comes out of the Model Penal Code. It's been the law of our state since 1979, and it's intended to encourage merchants to take the self-help steps they need to recover their own merchandise. So let me see if I can find this here. A merchant who causes the arrest of a person for shoplifting, as provided in this section, shall not be criminally or civilly liable in any manner or to any extent whatsoever where the merchant has probable cause for believing that the person arrested committed the offense of shoplifting. What's that mean?
That means that if the store representative, the store detective, whatever you want to call them, security representative, loss prevention representative, has probable cause to believe that a certain person is shoplifting, they cannot be either held criminally liable for detention or civilly liable in superior court for any type of wrongful detainment.
Okay. I'll tell you about a case I did many, many years ago. Shoplifting case. And they arrested this person, the store security people arrested the person for shoplifting and broke her arm. Okay. And she tried to come back at them with aggravated assault, breaking her arm. Prosecutor's office didn't want anything to do with it, so they downgraded it to municipal court. We tried the case there. And the judge, I forget which side I was on now that I think about it, but the judge acquitted the store people of breaking her arm based upon the statutory immunity. And I'm thinking to myself, then why don't they just kill him? Okay, just take your gun out and shoot him. Okay, if the immunity is that broad. But I don't think anybody's willing to argue that you can use deadly force under these circumstances. So the amount of force that they can utilize, I guess, just has to be reasonable.
Reasonable force, absolutely.
But that's going to come under another statute. It's not in here. The statutory immunity doesn't limit them to acting reasonably. It's just a general statutory immunity from civil or criminal liability. And again, its purpose is to encourage them to recover their merchandise. Now, shoplifting is also one of the few offenses that police officers can effect an arrest when it does not occur in their presence. And normally shoplifting is not going to occur in their presence.
Absolutely.
So what we're dealing with technically is a citizen's arrest, and they're detaining the individual under arrest until the police come to take them into physical custody and remove them back to the police station.
Absolutely.
So here's the statute. It's under subsection E. A law enforcement officer, a special officer, or a merchant. So all three of those come under that. Two of these three are going to be non-law enforcement. If they have probable cause for believing that a person has willfully concealed merchandise and that he can recover the merchandise by taking the person into custody, may, for the purpose of attempting to effect the recovery, take the person into custody and detain him in a reasonable manner for not more than a reasonable time. Okay? Now, notice that the taking into custody doesn't have to be done reasonably. It's the detention of the individual. Okay? And the amount of time the person can be detained also has to be reasonable. And taking into custody of a law enforcement officer or special officer or merchant shall not render such person criminally or civilly liable in any manner to any extent whatsoever. Okay? Then it goes on to say this: any law enforcement officer may arrest without a warrant any person he has probable cause to believe has committed the offense of shoplifting, as defined in this section. So we take shoplifting and we're going to throw it into the same category as domestic violence, theft of library materials, which is really nothing more than shoplifting of library materials under 20-12. Drunk driving. Am I skipping any? I don't think so.
I don't think so, no.
So those offenses, shoplifting, theft of library materials, domestic violence, and drunk driving, are petty offenses which the police officer who would normally have to have either an arrest warrant or the offense would have to be committed on view or in the presence of the officer. In other words, the officer would have to perceive it in real time as it happens. But for those four offenses I've just mentioned, it doesn't matter. The officer, if he has probable cause, regardless of how he develops probable cause, can affect the arrest.
Absolutely.
Okay. So the merchant, to the extent the merchant is making a citizen's arrest, the citizen's arrest only entitles the merchant to detain this individual in a reasonable manner for a reasonable period of time. Presumably, to let the police come over and take these people away.
On their perp walk.
Right, the perp walk. Now,
through the store.
Just in terms of what happens after they get back to the police station. All right. Did you ever get involved in these cases at this point to determine whether or not the complaint was going to go on a summons or a warrant?
Yes.
Why?
Well, you may have situations, this is before bail reform, you may have situations whereby the defendant had a prior record, and this was made known to the attention of the court, that they either had cases pending or they had a long prior record of shoplifting.
Without a warrant, some other court?
A warrant in some other court. These were situations whereby the police were asking for the complaint to be placed on a warrant with bail.
Okay.
And in most of those cases, I would grant the request. Now, for the disorderly person defense, the maximum bail under the statute could be up to $2,500.
Okay.
No more than $2,500, unless there were indications of special circumstances which a judge had to put on a record.
Would you ever let the police make their own determinations on these things that they're going to do on a summons?
No.
No?
Well, no, they wouldn't put it on a summons. They didn't have to call me.
If they're going to put it on a summons?
Yes.
All right, but I guess I'm asking the wrong question here. There's a preliminary question. Who did you demand be the complainant? Is the store that going to come be the complainant, or the officer going to be the complainant?
That would be the choice of the state.
Okay, you don't care.
I don't care.
Okay. But if the store is going to be a complainant, somebody's going to have to look at affidavit of probable cause, right?
Yes.
Regardless of whether you're going to do it on a summons or a warrant.
Right.
Would you yourself do that, or would you have the court staff make the PC determination?
That would be made by the court staff.
Okay. So if you have
and if it was a warrant request, I would have to hear the probable cause facts before I decide to find probable cause issuance of the complaint, authorize the warrant, and impose bail.
Would you swear the officer in and do it over the phone?
Absolutely.
Okay. And then, but if the officers, let's look at it this way. If the store is going to be the complainant, all right, a judicial officer is going to have to make a determination of probable cause, either whether it's a summons or a warrant.
That's correct. That's correct.
But if it's going to be prepared on a warrant, I guess you'd have to make that decision, right?
Yes.
Okay. If it's a police complaint and the police are going to release the person under the summons, you don't get involved.
That's right.
But if the police want it prepared on a warrant, they got to call you.
That's right.
So you'd have to make two decisions. A, is there probable cause for me to believe the offense took place? And B, is it justified to be placed on a warrant?
And C, if I find it's justified to be placed on a warrant, what would be the bail amount?
Now, with bail reform, that C is off the table.
C is off the table
Right.
now.
You don't have to worry about that anymore.
Right. Well, and there's the other stuff they have to go through the county prosecutor as well.
Oh, sure. But I'm saying it's just, once it's on a warrant, it's on a warrant, and it has its own track
They're
now.
going off the jail.
Right. Now, an additional thing I want to talk to you about, and I think this was part of the original statute where the shoplifting was always considered a disorderly person offense no matter how much he stole. The amendments to the statute then graded it like any other theft.
Yes.
So conceivably, if you stole $200 worth of stuff, it goes to the county prosecutor's office.
More than 200, yes.
These would be downgraded 100% of the time. And
A large percentage, yes.
the reason for that, at least what the prosecutors tell me, is we are not going to waste our resources on a case that has no jury appeal whatsoever. And oh, by the way, the defendant is going to get more punishment more quickly in municipal court than he ever will in superior court. Okay? And back in the day, so to speak, that caused all kinds of problems for the defense bar because I didn't want my case downgraded, especially if I had a legitimate shot to get into the PTI. And I would call them up and say, please don't downgrade this. I want him to get PTI, But you'd have to know somebody. The prosecutor's office would have to be friendly to you. And then sometimes I'd have the opposite case where the guy would have like $198 worth of stuff he stole. And I'd call the prosecutor's office up and say, listen, can you do me a favor, upgrade this? My guy shouldn't be punished because he didn't steal enough, okay? And I'd say, you got to take into consideration sales tax. You take the sales tax into consideration, and all of a sudden it's over $200. I mean, I used to have to come up with all these stupid arguments to try to get my client into PTI. The conditional dismissal program has got rid of all that. And
yes.
It's a very, very big help in terms of case disposition. But I can't imagine a prosecutor's office keeping one of these cases that had a value that would be less than $200, just slightly over $200. Can you?
No. As a matter of fact, I've had those arguments made to me. Send it back, please, to the prosecutor's office because we want to try to get PTI.
Okay, but not necessary anymore.
Well, maybe. I mean, maybe if because there may be circumstances where the defendant has a prior record and still may be eligible for PTI, we're not eligible for conditional dismissal.
Right. You know, the ones that used to kind of disappoint me would be shoplifting cases where there was injury sustained either because of fighting at the time of arrest and one of the merchants or the store security people would be injured, or there's a chase into a parking lot and somebody gets injured in the parking lot during the apprehension. And these kids, they get rid of them as robberies, and then they get downgraded to, to theft and simple assault or whatever it is.
Yes.
And it just seemed to me that this was not particularly fair to the store personnel.
Well, that's a statewide phenomenon. That's just not.
You saw that too?
Oh, absolutely, all the time.
And I saw also, which made it even sadder, that many times the stores did not support their employees at all. Occasionally there would be charges filed against the store employees, either for simple assault or for wrongfully detaining these individuals. I forget what this DP is. What do they call that? Do you remember the statute for that, Judge? It's where you wrongfully detain an individual.
False imprisonment.
False imprisonment. It's a disorderly persons level offense.
Yes.
So I'd see that charge sometimes, and other types of DP level offenses. Sometimes it would be well-founded, sometimes just be retaliatory. And these individuals, they'd be on their own. The store wouldn't pay for an attorney for them or anything like that.
Right.
They just have to take care of it. Do you ever see that?
Absolutely.
And you have any problem with any of that?
Well, in my recollection, in most of those cases, they had a store-provided attorney.
That was not the case up in my neck of the woods, so to speak.
Yeah.
But I always felt bad about that.
Oh, yeah.
What these individuals get. So we've kind of covered the waterfront here on shoplifting. There's some extremely sensitive issues. These are complex cases, and many times not necessarily involving guilt or innocence, although that can be complicated. But sentencing in particular can be the hard part of these cases. Would you agree?
Absolutely.
So for the judges who are watching this, are going to have to deal with these things. What kind of words of wisdom can you give them?
Get a criminal history in every shoplifting case.
Right.
Have it ready in the file. Don't look at it in advance, but have it ready in the file. So when it comes to sentencing, you're prepared to deal with sentencing issues.
Right.
And just like in traffic cases where you have drunk driving or driving while suspended, driving no insurance, you see an accident. In all those cases, you have an abstract in the file. Have your court administrator order a CCH before and put it in the file, in the back of the file, so you'll have it in every shoplifting case. So that if it comes to sentencing, you'll have a complete criminal history of the defendant in the state of New Jersey.
My advice to the judges is this. If you get a plea offer for the prosecutor or the defense attorney, which calls for a downgrade, an amendment, a dismissal, or some other type of unusual disposition, other than being straight sentencing under shoplifting, you've got to ask a lot of very difficult questions. You want to hear from the merchant. You're going to want to hear from whoever the arresting officer was. You're going to want to really delve into what is the reason for this diversion. And it may be totally justified on the facts, but you as a judge really have to dig and do a painstaking and searching inquiry about these things.
Yes.
To make sure, because ultimately it's you as judge, it's your responsibility to make sure that individual justice is done in individual cases. And you're not going to be able to do that unless you know exactly what's going on. It may be a completely justified amendment, but you've got to be satisfied in your own mind that it is.
I've had more than one attorney argue to me that this is after conviction or upon a plea of guilty, this is the defendant's first offense for shoplifting. They have 3 or 4 priors.
Well, they meant today. It's their first offense today.
Well, they had 3 or 4 priors in the past, and of course they don't have access to the CCH.
Right.
Their client's telling them one thing, but the CCH does something else.
What I'm really more concerned about is the situation where the prosecutor's asking for something other than shoplifting. Let's say they want an amendment to harassment or improper behavior, and you start asking why, and they say because there's a forfeiture of public office here. Now you got to think real long and hard as to whether or not prosecutors should be involved in that, whether that's in the interest of justice, or that they're trying to help a person avoid going to jail for mandatory third offense, without any other justification other than this is what they want to do. You may have situations when you start exploring that the prosecutor is a perfectly valid, litigatable case. They can make a prima facie case for shoplifting, and the amendment they're seeking not justified.
I agree. Yes.
Okay. So, do you think it's a good idea for judges to really do, again, a painstaking and searching inquiry?
Absolutely. Absolutely.
Okay. Don't be afraid to ask the questions.
No.
Right?
Absolutely.
You may make an enemy of your prosecutor.
There's
right?
two other issues I'd like to discuss.
Sure, Judge.
Number one, there is no conspiracy to shoplift in the state of New Jersey because it's a solely person defense in municipal court.
Correct.
However, there is accomplice liability under 2C26.
Yes.
And if you're involved in the facilitation or the commission of the offense, and you don't actually have the items in question on your person when you all leave the store, you can be just as guilty of the person who committed the offense of shoplifting, who had the items on the store, if you are a lookout, or
You're an accomplice.
you're the driver outside under accomplice liability.
Correct.
Okay?
Yep.
Number one.
May I stop you on number one?
Sure.
One other thing that the judges should keep in mind is this, that if they used an automobile to go there or drive away, one of the things
The getaway driver.
Right. They can suspend the driving privileges for up to 2 years on the individual who was driving since a motor vehicle was used in the commission of the offense. I think that's under 2C43-2C. The only thing the judge should understand is when you're sentencing someone to a license suspension is that you have to make a determination as to what impact the license suspension is going to have on the ability of the defendant to rehabilitate himself. But watch for those cars that have automobiles. Very, very important.
Yes.
What was your second thing, Judge?
Okay, I ran a shoplifting course.
To teach him how to do it better?
No, it was really a misnomer. It was an anti-shoplifting course.
Okay.
And I ran that for over 30 years.
What's the curriculum? What were you trying to do?
I was trying to dissuade people from continuing their bad habit of shoplifting. Because, as we all know, a person shoplifts maybe 10, 20, 50 times before they're caught first time.
The good ones, anyway.
Well, and it was a course designed to look at shoplifting through many angles. First, the store's angle, profit margins, which we already discussed. Second, through the police angle, why the police handcuff you when you're arrested, why they walk you through the store, why they do certain things at the police department. In other words, under the shoplifting statute, you are, even for disorderly persons offense today in New Jersey, you're required to be fingerprinted and photographed, unlike other disorderly persons offenses.
Right, they have to do post-arrest identification procedures.
Right, because there's a lot of people who give false names in subsequent shoplifting charges, hoping to get off on that basis.
Correct.
And we've had trials of that analysis of fingerprints involving whether that person had a prior record of shoplifting based upon their fingerprints. We also look at it from a probation point of view, because in Atlantic County at least, probation ran the community service aspect of the court sentence, which was mandatory. And finally, from the jail point of view. And also we looked at it from employment issues, because a lot of people in Atlantic County had casino licenses. And if they had been charged and caught with shoplifting and convicted, they had obligation to report that upon renewal or upon their first application for a casino license.
Was there an immigration issue as well, Judge?
Yes. But that would be discussed on a case-by-case basis in the courtroom.
Got it.
Okay. But the shoplifting course was held once every 6 months, and I gave out a suspended jail sentence with the condition that they attend the shoplifting course. And this was the deal. If the person attended the course and they had no other charges for shoplifting, that's great. If they attended the course, though, and say it was a first offense, if they came before me on a second offense for shoplifting and they were convicted, they would leave the courtroom to go directly to jail. No diversion.
Just like in a drunk driving case.
And it would be 15 days. This was approved by the assignment judges in Atlantic County over the years. They thought it was a great program. And it resulted in a lot of people, shoplifters, who got out of that situation very early. I had a lot of people come up after the course and thank me for having the course, because the last part of the course we held was at the county jail. So we actually took these defendants into a housing unit at the county jail to show them what it'd be like if they were reincarcerated or incarcerated for the first time, perhaps, for shoplifting, if they continue with their shoplifting ways, because as we all know, on third offense, it's a mandatory 90 days.
Right.
So it was very, very helpful, and a lot of people were very appreciative that I gave the course. Never told those people again.
It seems to me like you have an enormous amount of pride in it.
Oh, I do, because I feel we help a lot of people get out of that cycle of crime.
You need the support of your assignment judge to do that.
Absolutely.
Plus you have to care enough about to do it in the first place.
Well, I'd had to take 2 Saturdays out of the year and go to jail on those Saturdays. We'd had the course from 9 a.m. in the morning, 12:30 in the afternoon, 3.5 hours. Right. We'd have attorneys come and speak. This was all done pro bono. I had no money for the course. Right. The people were told that I had no money for it. I couldn't pay anybody to come to the course because I had no money for it. We'd have people from the stores come over, the store representatives to come over and talk about shoplifting. They'd bring tapes over and show what happened to certain tapes, like from Boscov's. We'd have a representative from county probation and a person from the jail who would speak last about the jail experience.
So I wanted to share one final thought with you. You might have picked this up in your shoplifting classes. I'm trying to categorize the people that I had as defendants over the years for shoplifting. And a percentage, and I'd say a relatively small percentage, certainly no more than 10%, are just out-and-out criminals. This is just what they do, and nothing is going to deter them. And if they get caught and they go to jail for 6 months, it's just a cost of doing business. And
well, you have certain IV drug users.
Well, that's the second category. I mean, we then had a very big population. It might have been as much as 50 or 60% of my clients that were IV drug users or inveterate drug users, and they're stealing for a quick turnover so they can sell the merchandise.
Hence the items on the outside.
Exactly.
And get the money for drugs.
And then the rest of them would just be a combination of people who were desperate for money, not for drug use necessarily. We had some people that just had very severe psychiatric problems or psychological problems. Many of them were doing this in hopes that they got caught. I'm not a doctor. I'm barely a lawyer. I can't account for what motivated these individuals to do it because there's really no discernible reason for them to be involved in shoplifting. They have jobs. They have money. They didn't need the merchandise they were taking. It was just an impulsive, idiotic thing for them to do. And many times you'd see, steady, solid, middle-class people, married women, men with jobs and things like that, engaging in this impulsive behavior.
Elderly and wheels and
very frequently.
Walkers.
Very frequently.
Now, we also had, since I was at the shore, we also had, the end of the summer, we had students from Eastern Europe or from all over the world.
But they've been there working?
Working on a student visa.
Right.
And they'd come in and shoplift before they got on the plane to go back to wherever they came from. And we'd have problems then with getting interpreters in the courtroom. If they could appear, if they were convicted or they pled guilty, could they come back for the shoplifting course? It was like the swallows returning to Capistrano.
Right.
Because every year we could count on having 60 or 70 students from primarily Eastern Europe who would come in and try to shoplift. And so they wouldn't speak any English. We once had a person come in, this boyfriend come in, and 2 girls who were charged with shoplifting, and says, I know they are a flight risk, but why are you imposing bail? That's the reason why I'm imposing bail in the first place.
Well, it's really more, instead of the swallows coming back to Capistrano, it's really more like the laughing gulls coming back to Estelle Manor.
Right.
Anyway, Judge, you've been very, very helpful today. I hope you'll make yourself available to any of the judges watching here if they want to call you up. And,
absolutely.
We'll put a number on the screen where they can reach you.
Absolutely.
And give them the benefit of your years of experience.
Absolutely.
And Judge Switzer, thank you very much for being here today. It's been very enlightening and I hope helpful to our audience.
No problem. Thank you, Bob.
Thank you, Robert.
for it and put it in the file, in the back of the file, so you'll have it in every shoplifting case, so that if it comes to sentencing, you'll have a complete criminal history of the defendant in the state of New Jersey.
My advice to the judges is this. If you get a plea offer for the prosecutor and the defense attorney, which calls for a downgrade, an amendment, a dismissal, or some other type of unusual disposition other than being straight sentencing under shoplifting, you've got to ask a lot of very difficult questions. You want to hear from the merchant. You're going to want to hear from whoever the arresting officer was. You're going to want to really delve into what is the reason for this diversion. And it may be totally justified on the facts, but you as a judge really have to dig and do a painstaking and searching inquiry about these things.
Yes.
To make sure, because ultimately it's you as judge, it's your responsibility to make sure that individual justice is done in individual cases. And you're not going to be able to do that unless you know exactly what's going on. It may be a completely justified amendment, but you've got to be satisfied in your own mind that it is.
I've had more than one attorney argue to me that this is after conviction or upon a plea of guilty, this is the defendant's first offense for shoplifting. They have 3 or 4 priors.
Well, they've been today. It's a first offense today.
Well, they had 3 or 4 priors in the past, and of course they don't have access to the CCH.
Right.
Their client's telling them one thing, but the CCH does something else.
What I'm really more concerned about is the situation where the prosecutor's asking for something other than shoplifting. Let's say they want an amendment to harassment or improper behavior, and you start asking why, and they say because there's a forfeiture of public office here. Now you got to think real long and hard as to whether or not prosecutors should be involved in that, whether that's in the interest of justice, or that they're trying to help a person avoid going to jail for mandatory third offense, without any other justification other than this is what they want to do. You may have situations when you start exploring that the prosecutor's a perfectly valid, litigatable case. They can make a prima facie case for shoplifting, and the amendment they're seeking not justified.
I agree. Yes.
So. You think it's a good idea for judges to really do, again, a painstaking and searching
Absolutely,
inquiry?
Absolutely.
Okay. Don't be afraid to ask the questions, right?
No, absolutely.
You may make an enemy of your prosecutor.
There's
right?
2 other issues I'd like to discuss.
Sure, Judge.
Number 1, there is no conspiracy to shoplift in the state of New Jersey because it's only a person defense in municipal court.
Correct.
However, there is accomplice liability under 2C26.
Yes.
And if you're involved in the facilitation or the commission of the offense, and you don't actually have the items in question on your person when you all leave the store, you can be just as guilty of the person who committed the offense of shoplifting, who had the items on the store, if you are a lookout, or you're
an accomplice.
You're the driver outside under accomplice liability.
Right.
Okay?
Yep.
Number 1.
May I stop you on number 1?
Sure.
One other thing that the judges should keep in mind is this. That if they used an automobile to go there or drive away, one of the things
the getaway driver.
Right. They can suspend the driving privileges for up to 2 years on the individual who was driving since a motor vehicle was used in the commission of the offense. I think that's under 2C43-2C. The only thing the judge should understand is when you're sentencing someone to a license suspension is that you have to make a determination as to what impact the license suspension is going to have on the ability of the defendant to rehabilitate himself. But watch for those cars that have automobiles. Very, very important.
Yes.
What was your second thing, Judge?
Okay, I ran a shoplifting course.
To teach him how to do it better?
No.
Okay.
It was really a misnomer.
Right.
It was an anti-shoplifting course.
Okay.
And I ran that for over 30 years.
What's the curriculum? What were you trying to do?
I was trying to dissuade people from continuing their bad habit of shoplifting. Because, as we all know, a person shoplifts maybe 10, 20, 50 times before they're caught first time.
The good ones, anyway.
Well, and it was a course designed to look at shoplifting through many angles. First, the store's angle, profit margins, which we already discussed. Second, through the police angle, why the police handcuff you when you're arrested. why they walk you through a store, why they do certain things at the police department. In other words, under the shoplifting statute, you are, even for disorderly persons offense today in New Jersey, you're required to be fingerprinted and photographed, unlike other disorderly persons offenses.
Right, they have to do post-arrest identification procedures.
Right, because there's a lot of people who give false names in subsequent shoplifting charges, hoping to get off on that basis.
Right.
And we've had trials involved analysis of fingerprints involving whether that person had a prior record of shoplifting based upon their fingerprints. We also look at it from a probation point of view, because in Atlantic County at least, probation ran the community service aspect of the court sentence, which was mandatory. And finally, from the jail point of view. And also we looked at it from employment issues, because a lot of people in Atlantic County had casino licenses. And if they had been charged and caught with shoplifting and convicted, they had an obligation to report that upon renewal or upon their first application for a casino license.
Was there an immigration issue as well, Judge?
Yes. But that would be discussed on a case-by-case basis in the courtroom.
Got it.
Okay. But the shoplifting course was held once every 6 months, and I gave out a suspended jail sentence with the condition that they attend the shoplifting course. And this was the deal. If the person attended the course and they had no other charges for shoplifting, that's great. If they attended the course, though, and say it was a first offense, if they came before me on a second offense for shoplifting and they were convicted, they would leave the courtroom to go directly to jail. No diversion.
Just like in a drunk driving case.
And it would be 15 days. This was approved by the assignment judges in Atlantic County over the years. They thought it was a great program. And it resulted in a lot of people, shoplifters, who got out of that situation very early. I had a lot of people come up after the course and thank me for having the course, because the last part of the course we held was at the county jail. So we actually took these defendants into a housing unit at the county jail to show them what it would be like if they were reincarcerated or incarcerated for the first time, perhaps, for shoplifting, if they continue with their shoplifting ways, because as we all know, on third offense, it's a mandatory 90 days.
Right.
So it was very, very helpful, and a lot of people were very appreciative that I gave the course. Never told those people again.
It seems to me like you have an enormous amount of pride in it.
Oh, I do, because I feel we help a lot of people get out of that cycle of crime.
You need the support of your assignment judge to do that.
Absolutely.
You have to care enough about to do it in the first place.
Well, I'd had to take 2 Saturdays out of the year and go to jail on those Saturdays. We'd had the course from 9 a.m. in the morning, 12:30 in the afternoon, 3.5 hours. Right. We'd have attorneys come and speak. This was all done pro bono. I had no money for the course. Right. The people were told that I had no money for it. I couldn't pay anybody to come to the course because I had no money for it. We'd have people from the stores come over, the store representatives to come over and talk about shoplifting. They'd bring tapes over and show what happened to certain tapes, like from Boscov's. We'd have a representative from county probation and a person from the jail who would speak last about the jail experience.
So I wanted to share one final thought with you. You might have picked this up in your shoplifting classes. I'm trying to categorize the people that I had as defendants over the years for shoplifting. And a percentage, and I'd say a relatively small percentage, certainly no more than 10%, are just out-and-out criminals. This is just what they do, and nothing is going to deter them. And if they get caught and they go to jail for 6 months, it's just a cost of doing business. And
well, you have certain IV drug users.
Well, that's the second category. I mean, we then had a very big population. It might have been as much as 50 or 60% of my clients that were IV drug users or inveterate drug users, and they're stealing for a quick turnover so they can sell the merchandise.
Fancy items on the outside,
exactly.
And get the money for drugs.
And then the rest of them would just be a combination of people who were desperate for money, not for drug use necessarily. We had some people that just had very severe psychiatric problems or psychological problems. Many of them were doing this in hopes that they got caught. I'm not a doctor. I'm barely a lawyer. I can't account for what motivated these individuals to do it because there's really no discernible reason for them to be involved in shoplifting. They have jobs, they have money, they didn't need the merchandise they were taking. It was just an impulsive, idiotic thing for them to do. And many times you'd see, steady, solid, middle-class people, married women, men with jobs and things like that, engaging in this impulsive behavior.
Elderly and wheelchairs and
Very frequently.
walkers.
Very frequently.
Now, we also had, since I was at the shore, we also had, the end of the summer, we had students from Eastern Europe or from all over the world.
But they've been there working?
Working on a student visa.
Right.
And they'd come in and shoplift before they got on the plane to go back to wherever they came from. And we'd had problems then with getting interpreters in the courtroom, if they could appear, if they were convicted or they pled guilty, could they come back for the shoplifting course? It was like the swallows returned to Capistrano.
Right.
Because every year we could count on having 60 or 70 students from primarily Eastern Europe who would come in and try to shoplift. And so they wouldn't speak any English. We once had a person come in, this boyfriend come in, and two girls who were charged with shoplifting, and says, I know there are a flight risk, but why are you imposing bail? That's the reason why I'm imposing bail in the first place.
Well, it's really more, instead of the swallows coming back to Capistrano, it's really more like the laughing gulls coming back to Estelle Manor.
Right.
Anyway, Judge, you've been very, very helpful today. I hope you'll make yourself available to any of the judges watching here if they want to call you up. And,
absolutely.
We'll put a number on the screen where they can reach you.
Absolutely.
And give them the benefit of your years of experience.
Absolutely.
And Judge Switzer, thank you very much for being here today. It's been very enlightening and I hope helpful to our audience.
No problem. Thank you, Bob.
Thank you, Rob.
To be a serious problem.